Okay, so welcome back to part 2 of chapter 4, our lecture on search and seizure, and a lot of ground to cover still, so we're going to jump back in and we're going to start with searching of passengers in a stopped vehicle, and then we'll jump into inventory. So if there are passengers inside of a private vehicle that is stopped, their rights may differ from those of the driver, but they are all considered detained at the stop. And passengers may also be ordered out and kept from leaving. Passengers may also be arrested for joint possession of contraband. And passengers' property and the vehicle may be searched incident to their arrest. Of course, you're going to need probable cause, so don't forget about that. Now, in a case Wyoming versus Houghton, an officer may search an automobile passenger's belongings simply because the officer suspects the driver has done something wrong. Now, this passenger property exception ruling was intended to prevent the driver from claiming that illegal drugs or other contraband belong to the passengers rather than themselves. And that's not applicable in every situation, but you need to know the cases there. And then another case, Brendlin versus California, the Supreme Court held that all passengers inside of a vehicle during a traffic stop are technically seized, just as the driver. And a logical outgrowth of this ruling followed in a case called Arizona versus Johnson, when the court determined that an officer may frisk a passenger in a car that has been lawfully stopped for a traffic violation if the officer has developed that reasonable suspicion that the passenger is armed. So remember that the Terry thing, okay? So what about an inventory? So police do have the right to inventory a car. So when police take custody of a vehicle, let's say they arrest someone and they take custody of a car or other property, the courts have upheld their right to inventory the contents of the vehicle for a couple of reasons. One, to protect the owner's property. Two, to protect the police from disputes and claims that the property was stolen or damaged. Three, to protect the police from the public from danger. Sometimes there might be different types of things in a vehicle. Let's say explosive devices, chemicals. Sometimes I remember finding a hand grenade in a car during an inventory search. So there are things out there. And then finally, to determine the owner's identity. So the courts have held that any one of these factors outweighs the privacy interests of property and therefore justifies an inventory search. Now, the search must also be reasonable as well. Okay, so that's inventory searches. So what about something a little bit more interesting and more technical, like checkpoints? You know what a checkpoint is? It's where the police set up an area and they kind of have cones lined up and a sign that says, checkpoint ahead. So roadblocks and checkpoints, while technically seizures because they involve an investigative stop, are really important because they really are, they're a search in essence. And more than a quarter century ago, in a case United States versus Martinez Fuerte, it's 1976, the Supreme Court ruled that vehicle checkpoints at the country's borders were constitutional because they served as it's kind of a national interest, and that interest outweighed the minimal intrusion. So here we're talking about border checkpoints, if you will. Michigan versus Sitz in 1990 established that sobriety or DUI checkpoints were constitutional to combat drunken driving, and again that they were reasonable. In another case, Illinois versus Lidster in 2004, the court upheld the constitutionality of informational checkpoints, meaning let's say you have a youngster that's been kidnapped from a city area and you have an area set up where you're going to stop vehicles and they go through this checkpoint and you hand out flyers So these are instances where checkpoints are legal. Now, in one other case, and this was City of Indianapolis versus Edmond, and this was in 2000, the courts held that checkpoints for drugs are unconstitutional, stating that we cannot sanction stops justified only by the generalized and ever-present possibility that interrogation and inspection may reveal that any given motorist has committed some crime. Thus, vehicle checkpoints for general crime control are constitutionally unreasonable. So it's not a fishing expedition. You can't just stop people. Now, at the border, remember, it's different. At airports, remember, it's different because there's a different level of legality there, okay, because of issues related to terrorism and different things like that, and drug smuggling and stuff like that. But just basic general crime type checkpoints you can't have. Okay, so now let's look at something that's super interesting. And we're going to talk a little bit about plain sense evidence. So the limitations on searches are intended to protect the privacy rights of all citizens and to ensure due process of law. They're not intended to hamper investigations, nor do they preclude the use of evidence that is not concealed and is accidentally found through any of the officer's senses. The courts recognize that expecting officers to turn a blind eye to contraband or to postpone acting on something that they sense is illegal and is unreasonable, essentially allowing that when officers have the legal right to be where they are, they have a right to see, hear, and smell, and faculties that may be used to detect plain sense evidence. So if you're in a place where you're lawfully allowed to be, the courts, say that you can use this plain view, plain feel, plain smell, plain hearing. These are the most common types of plain sense evidence. And again, just to kind of let you know, again, so it's plain view, plain feel, or touch, plain smell, and plain hearing. So let's talk briefly about each one. Plain view evidence is unconcealed evidence that is seen by an officer engaged in lawful activity. And the plain view doctrine, which is something we'll talk about in a few minutes, this doctrine permits the warrantless seizure of contraband or evidence of a crime and allows its admissibility in court provided the officers are legally allowed to be where they are. And this doctrine puts few constraints on officers and often yields very productive results. So if you see something in plain view and you immediately observe it and you believe it to be contraband, you can seize it. So if you're inside somebody's home and you've been invited in there and you're lawfully there and you look over and you immediately observe something that's contraband, you can seize it. Now, if you want to search the rest of the house, you're going to have to get a warrant or consent, but you can still seize anything that's in plain view, providing that you have a lawful reason to be where you are. Okay, what about plain feel or touch? So the plain feel or touch exception is an extension of the plain view exception. If a police officer lawfully pats down a suspect's outer clothing and feels an object that he or she immediately identifies as contraband, in other words, plain feel, plain touch evidence, a warrantless seizure is justified because there is no invasion of the person's privacy beyond that already authorized by the officer's search for weapons. And I'll show you a visual example in a minute. But think of it like this. If you've ever held like a a real firearm or even a cap gun or something that's shaped like a gun, if you were to put that in your pocket, and you can't see it, but if you were to feel it, you could feel that it's got that shape like a gun. That's what the court is talking about. Now, it gets a little bit more defined, but that's kind of the emphasis. Well, what about plain smell? Well, evidence may also be seized if an officer relies on a sense other than sight or touch. So, for example, a customs officer who smells marijuana coming from a package has probable cause to make an arrest under the plain smell rationale. And some odors like gasoline or things like that, chlorine, even like, let's say, phencyclidine, are easily detectable to officers investigating certain types of crimes. So merely smelling the air surrounding a suspect or something like that, and that's also with like canines, so I don't want to kind of get too far ahead. Some odors are commonly detected by canines, and they can use the sense of smell as well. But I mean, think of it like this: if you've ever smelled alcohol, so if you were to pull somebody over in a traffic stop and they rolled their window down and you smelled alcohol, that would give you a little bit more to start stacking on your case that maybe the person would be under the influence. Does that kind of make sense? So you have the plain smell. And then plain hearing. Officers or undercover officers can position themselves in accessible locations where they can overhear criminal conversations without any extraordinary listening devices like wiretaps or something. So anything overheard can be used in evidence. So if you're sitting at a restaurant and you're undercover and you hear somebody behind you talking about committing a crime, well, that's plain hearing. There's no expectation of privacy because they're in that place. So hopefully those kind of make sense. So giving you kind of an example, I talked about a bulge. Now you can here you have plain sight, and when you touch it, you'll have plain feel. Does that look like the outline of a firearm? Same here, and maybe you can't quite see it as much. So here you can see it here, kind of a bulge, in here. And if you patted the person down, if you felt it, you would really, really feel it. Okay. Same with here. And again, I'm giving you a bunch of different pictures to show you that it's not just men. It could be women if you patted them down. And I want to show you this because sometimes things are concealed in various ways. Now, obviously, your pat down, you have to be careful, and we'll talk a minute about the way to search and things like that. But they can be anywhere and right underneath somebody's pants along the belt line. Okay, but if you were patting and frisking somebody on the top right here on the outer clothing and you felt that, you would have the right to retrieve that. Very interesting dynamic. Heroin balloons, if you don't know what these are. And they use balloons because they pack the heroin in the balloon. They hold 2 or 3 balloons in their mouth, and if they're approached by law enforcement, they swallow the balloons and they will excrete them later and then resell them. Yeah, I know it's kind of gross, but it is what it is. But this big baggie of these balloons, if you were to pat someone down and you felt this, through their clothing, and you could feel the best word I can say is boinginess of the objects, and if you felt them before and you were a narcotics investigator, you would know that those feel like heroin balloons or balloons. And you would know that balloons typically in that type of packaging typically would hold some type of drug, usually heroin. And then from there you could develop probable cause to actually remove the object. Same with like the smell. You get the visual and the smell. Same with, again, the smell. So these are the, or the hearing. You hear a gunshot, or you hear somebody say something. So these are the senses again. Okay, so what about open fields or abandoned property or public places? So just as when a suspect reveals incriminating evidence by exposing it to an officer's senses, or an officer's presence, a search is considered justified and legal when a suspect casts off any expectation of privacy, such as leaving contraband exposed and unattended in a public place. So again, while it may seem to be a natural extension of the plain view doctrine, the courts have tended to approach this area from a privacy perspective, ruling that anything held out to the public is not protected by the Fourth Amendment because no reasonable expectation of privacy or even physical trespass exists. So kind of an interesting case is the California versus Greenwood case. And here the U.S. Supreme Court ruled that trash containers left out publicly on public property outside of the person's property line, or curtilage, if you will, are open to search. And the court said in the ruling here that it's common knowledge that, garbage bags left on a public street are readily accessible to animals or children or scavengers or snoops or other members of the public, and therefore there's no reasonable expectation of privacy in these types of cases. So the most important factor in determining the legality of a warrantless kind of trash inspection is the physical location of where the trash is. And I kind of talked about that. And police cannot trespass to gain access to the trash location. And generally, the trash must not be located, again, within that curtilage thing. So the property line is kind of another way of putting it, which the Supreme Court has described as the area that extends the intimate activity associated with the sanctity of one person's home and the privacy of life. So in other words, the curtilage is that portion of a residence that is not open to the public. So it's reserved for the private owner or family use, like your front yard, and therefore an expectation of privacy exists. Now, this is in contrast to sidewalks, alleys, and things like that. So just kind of looking at the picture quickly, so even though they have a no trespassing thing, that's okay, but if this is all open, this is fair game. But if you go inside the fence line, the curtilage, even the porch or whatever, all this, so if your trash was in here, it would be not admissible. If it was out here, then it would be. So that's kind of the definition of what curtilage means. Okay, so now we're going to get into kind of a really cool part of the lecture, and all of it I think is great, but we're going to talk about the exclusionary rule. So through the exclusionary rule, courts enforce the prohibition against unreasonable searches set forth in the Fourth Amendment. And in the early 1900s, the federal courts declared that they would require evidence to be obtained in compliance with the constitutional standards that were set forth in the Fourth Amendment. So the exclusionary rule established that courts may or will not accept evidence obtained by unreasonable search and seizure, regardless of the relevance. It could be the smoking gun to a triple homicide, and it's not going to matter. And a couple of cases that are very important to this would be Weeks versus United States and Mapp versus Ohio. Because in the Weeks case, the exclusionary rule came about first, but it was only applicable to the federal officers or the federal government. But then when Mapp came around, that same rule then applied to the states. So now it's both state and federal, and it's because of both of those cases. So again, the exclusionary rule established that courts may not accept evidence obtained by unreasonable search and seizure, regardless of the relevance. And it was brought about federally first by Weeks versus United States, and then applicable, blah, 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 to all the courts in all the states in Mapp versus Ohio. And I have a little video if you want to watch that. Now, the exclusionary rule affects illegally seized evidence as well as evidence obtained as a result of the illegally seized evidence. And hopefully that makes sense. And that's called fruit of the poisonous tree. So this fruit of the poisonous tree doctrine establishes that evidence obtained as the result of an earlier illegal search must also be excluded from trial. Does that make sense? So if you illegally seize some evidence and that evidence leads you to some other really cool evidence, that's going to be the fruit of the poisonous tree. Sorry for the phone ringing, but I am at home. So again, evidence discovered illegally cannot be used to discover other evidence. And that's the fruit of the poisonous tree doctrine. So that's the exclusionary rule and again, the fruit of the poisonous tree doctrine. Okay, so what are some other exceptions? Well, one of them, again, and there's a couple of really interesting ones. One is the inevitable discovery exception. So this is the exception to, let's say, a search warrant. So in Nix versus Williams, another case in 1984, a defendant's right to counsel under the Sixth Amendment was violated, resulting in his making incriminating statements and leading the police to the body of his murder victim. And searchers who had been conducting an extensive systematic search of the area then terminated their search because the person took them to the body. If the search had continued, the search party would have inevitably discovered the victim's body. Thus, now we have the inevitable discovery exception. So this inevitable discovery doctrine or exception establishes that if legally obtained evidence would in all likelihood eventually have been discovered legally, it may be used. And there are some other exceptions, etc., but we want to touch on these just briefly for lack of time, because there are a few that we need to kind of go over. So that's one. Another one would be the good faith exception. So in a case called United States versus Leon, in Burbank, California, they were investigating a drug trafficking operation and following up on a tip from an unreliable informant, applied for and were issued an apparently valid search warrant. And their search revealed a lot of drugs and other evidence at different locations. Now, the defendants challenged the sufficiency of the warrant and moved to suppress the evidence based on the basis of the search warrant. And the district court held that the affidavit was insufficient to establish probable cause. Now, the U.S. Court of Appeals affirmed the district court's action. Well, then the U.S. Supreme Court reviewed whether the exclusionary rule should be modified to allow the admission of evidence seized under good faith. And the court noted that the exclusionary rule is a judicially created remedy. Remember, the exclusionary rule is something that the courts came up with. It's not in the amendments. The courts came up with this to kind of keep officers from violating the Fourth Amendment. So again, the court noted that this exclusionary rule is a judicially or court-created remedy intended to serve as a deterrent rather than a guaranteed constitutional right. So the good faith doctrine established that illegally obtained evidence may be admissible if the police were truly not aware that they were violating a suspect's Fourth Amendment right. So again, evidence seized in reasonably good faith can fall under the good faith doctrine. So now let's talk about, okay, I had to pause for a second. I'm sorry, I did have to deal with something. That's what happens when you have animals. So we left off, we talked about the exclusionary rule, we talked about the inevitable discovery exception, and we just got done with good faith. So now we want to get into the actual crime scene search. and kind of give you an overview. So we're not going to go super in depth, and we'll talk about different types of crimes as we kind of go down the line here. So the basic function of investigators is to conduct a thorough legal search at the scene of a crime. And even though not initially visible, evidence in some form is present at most crime scenes. Maybe not much, but there's usually a little. And although each crime scene is unique, certain general guidelines apply to this. And the goal of any search during an investigation at a crime scene or elsewhere is to really discover evidence that helps. And what is it going to help? Well, let's look. It's going to help establish that a crime was committed, and what that specific crime was. Establish when the crime was committed. Establish who committed the crime. Explain maybe how the crime was committed, and suggest why the crime was committed. A successful, let me kind of move the next slide here. A successful crime scene search locates, identifies, and preserves all evidence present. Evidence found at the scene assists in recreating the crime in much a same manner that bricks are properly placed, resulting in the construction of a building, or even putting a puzzle together. So, and furthermore, a meticulous, properly conducted search usually, not always, but usually will result in the discovery of some type of evidence. So how do we organize things? So after emergencies have been, attended to, the scene secured, witnesses have been located and separated, etc., there's going to be some things to do. So first, the security measures taken by the first officer on the scene are going to determine what evidence is discovered intact or after it's been destroyed. Because the first person on the scene is going to kind of secure the scene, and what they do to secure that scene sets the stage. And part of the issue when you're the first person there is to not to change or contaminate any of the physical evidence, and to also maintain a chain of custody. So, and this is part of organizing the crime scene and the crime scene search. So it's also important to set up or establish a kind of a crime scene base of operation, or headquarters, if you will. So again, after the emergencies have been attended to, because you want to do that first, the scene has been secured, etc., witnesses have been located and separated for interviewing, and the photography and sketching has been done, a plan for searching has to be kind of organized. And after organizing a search, you're going to want to start to divide some of the duties to everybody, selecting a search pattern for evidence, and assigning personnel and equipment, and giving instructions to other officers. Proper organization results through search with no accidental destruction of evidence. However, even the best organized searches may not yield evidence. So you want to at least be as organized as you can. And, keep in mind that evidence may have been destroyed before the search or removed by the criminal. In a few instances, evidence is just not there. So again, after things settle down, you're going to want to divide up the duties, figure out how you're going to search the area. You're going to assign different individuals to different tasks. And of course, you'll do that by giving instructions, but keeping in mind that you don't want to destroy evidence or contaminate anything within the scene. And as it relates to physical evidence, knowing what to search for is indispensable to an effective crime scene search. We already know what physical evidence is, but physical evidence is anything material and relevant to the crime being investigated. And because of that, physical evidence ranges in size from very large objects to really small, minute substances. And understanding what types of evidence can be found at various types of crime scenes is really important to the search, because not everything found at a crime scene is going to be used as evidence. So these are all important factors to understand and to keep in mind. Now, the elements of the crime also help determine what will be useful as evidence, meaning like what type of crime was it? So for example, a burglary requires an illegal entry, therefore maybe tool marks or broken glass in a door or a window might be evidence to help prove the burglary, etc. So know exactly what it is that you're looking for. And again, note that evidence might be found like right in the crime scene or near the crime scene or in an area or a route that's used to get to the crime scene. And sometimes evidence, again, same thing, might be found on or near the body. So if you're dealing with a homicide crime or something like that, keep in mind that evidence to that crime could actually be on the body itself. So it's important to understand everything as it relates to physical evidence. And one other thing to consider is this issue called elephant in a matchbox. And what this means is that it requires that searches consider the probable size and shape of evidence they seek. For example, large objects cannot be concealed in tiny areas. And so ignoring this doctrine can result in a search that wastes resources, destroys potential evidence, and it may actually even violate the Fourth Amendment if you have a search warrant, right? So I show you this is the same picture, but it's blank. So if I'm looking for large objects in this particular search, let's say distribution of 55-inch big screen TVs, where can I search? Can I search inside of this little bag? Would it be prudent? What if it was narcotics? Okay, so we went from big. So big is tough because we can't search certain areas. But what about some of the smaller areas if we're looking for bags of cocaine? Could they be hidden in smaller areas? So that's what they mean by the elephant in the matchbox doctrine. And again, not paying attention to that could be you violating the Fourth Amendment requirements on reasonable searches. Okay, so now let's talk a little bit about exterior searches. So when you talk about exterior searches, they can cover small, large, or vast areas. And they can also be divided into smaller areas. And you can even diagram your searches on paper, if you will. So all search patterns have a common denominator. They are designed to locate systematically any evidence at a crime scene or other area where evidence might be found. Now, most patterns involve partitioning search areas into workable spaces. So maybe kind of dividing them up into smaller areas, like I said. And the search pattern should be adapted to the area involved, the personnel available, and the time limits that might be imposed by, let's say, weather or lighting conditions, and the circumstances of the individual crime scene. So search patterns ensure thoroughness. So you're not just like looking out there and walking through and going, well, I didn't see anything. But if you have a pattern, it ensures thoroughness by hitting all the areas. So again, exterior searches can cover the small areas or large areas. Now, regardless of the dimensions, the area to be searched, again, can be divided into sub-areas and diagrammed on paper. And as each area is searched, you can check it off. And that kind of makes sense. And there are different types of searches. There's a lane search pattern, a circle search pattern, a zone or a sector search pattern. And again, depending upon weather or things like that, you may want to change your search pattern. Now, on page 119, there are some search patterns that are depicted in your book. Here are a couple of different ones. You might have up here, you have a strip or a line search, you have a grid search, a spiral search that would probably make me dizzy. You have a quadrant search, which a lot of times I do recall using. And sometimes you even have something a little kind of different. It's the wheel search. But typically you'll see a lot of law enforcement use the grid or the quadrant. But those are other search areas that are available. Well, what about interior? Well, most searches are interior searches. I mean, they are. The foregoing exterior search patterns can be adapted to an interior search of a crime scene. So you can use some of those exterior patterns inside. So they can kind of work, both ways. But of prime concern is to search thoroughly, but without destroying evidence. So, interior searches go, from the general to the specific, usually in a certain pattern, sometimes circular, covering all surfaces of the search area. And the floor should really be searched first. So in making an interior search, look closely at all room surfaces, including the floor, the ceiling, the walls, and all objects on the floor and the walls. Evidence can be found on any surface. The floor typically produces the most evidence, followed by doors and windows. And although the ceiling is often missed in a search, it too can contain some evidence like bullet holes or even blood stains. And it can even contain unlikely evidence like a footprint. But again, look closely at all the surfaces. Start general to specific. You can do it in a circular pattern. You can pick your pattern, but circular tends to work. Cover all the surfaces. And the floor needs to be searched first because that's where the most evidence is. And in bold, of course, pay attention to what you're doing so you don't destroy any evidence. And a couple of pictures, because sometimes you can see that scenes are extremely busy. A lot of things going on. So when you talk about not destroying evidence, sometimes you've got the fire crews in here and people walking in and out, and you've got extra footprints, and there's going to be some destruction of evidence. So try not to destroy evidence. And when you talk about finding evidence, there's all the different types of evidence, from clothing to handguns to shell casings, and then packaging the evidence. All of this goes along. And again, talking about investigatory searches, here's a systematic search covering, let's say, an entire area where you can kind of break it up into different areas, and then you can break those areas into quadrants. And this is a very systematic way of covering every type of area. So what about buildings? Well, this is a little bit different. When executing a warrant to search a building, officers should first be familiar with the location, discuss a plan of action, make sure you assess all of your resources, and you have to think safety, especially when you're serving a search warrant at a location where it could be, drugs or weapons or things like that. So do things like check records for any previous responses to the location, decide on the least dangerous time of day, or where there's not as many people there, etc. And just especially with a high risk warrant, there's a concept called the fatal funnel, and when you serve a search warrant, you have to be careful of those areas that expose you. So here, when you look at the open door, these are all areas that they call the fatal funnel, where if somebody were to fire a weapon, you could get caught in that particular area. So these are just, again, things that you still have to be aware of when you're talking about executing a search warrant, and in this case, kind of a high risk warrant. We talked a little bit already about building searches, dealing with the garbage searches. That's the Greenwood versus California case. We kind of talked about that. We talked about the fact of trash and the curtilage and stuff like that. Okay, so a little bit more on vehicle searches. Again, these are the investigative side of searching. So cars, aircraft, boats, motorcycles, buses, trucks, vans can contain evidence of a crime. And again, the type of crime determines the area to be searched and the evidence to be sought. In a hit and run accident, the car's undercarriage could have things like hairs or fibers, or the interior may reveal a hidden a liquor bottle hidden underneath the seat. In narcotics cases, various types of drugs are often found in cars, planes, and boats, and hidden in secret compartments. An ordinary vehicle has hundreds of places to hide drugs, and in some cases, vehicles have been, like I said, specifically constructed with compartments. So, as with other types of searches, a vehicle search must be systematic and thorough, and evidence is more likely to be found if two officers conduct the search. First, remove the occupants, search the area around the vehicle, then search the interior, search, side from front to back, and then return along the other side. So just have a systematic way to search vehicles. Wear protective gloves, because you never know what you're going to find, especially when you search vehicles or individuals where you could be stuck by a needle or something like that. So, when you search, definitely wear gloves. When you talk about suspect searches, again, how a suspect should be searched depends on whether an arrest has been made. If you have reasonable suspicion to stop or probable cause to arrest a person, be cautious. Many officers are injured or killed because they fail to search a suspect and they have a firearm on them. And if a suspect is in a car, have the person step out of the car and be careful to protect yourself from, a suddenly opening door. Before conducting any search, ask the person if they have anything on them that might injure you, like needles or razor blades or anything like that. If arresting the suspect, first handcuff them and then search the person, but again, wearing protective gloves. And if you arrest a suspect, conduct a complete search for weapons and any other type of evidence. So again, be thorough about what you do. Sometimes there are inhibitors to searching. And remember, I showed you the pictures of the ladies that had the firearms in some precarious places. So they do teach you how to properly search. You don't grope an individual. You use the back of your hand. But you still need to properly pat down an individual, especially a female, because they can hide objects. And sometimes an untrained officer or one that might be new might be afraid to pat down a female for fear of saying that they did something inappropriate. In that case, if you feel uncomfortable, you could always have a female officer come and assist with the search. But you can still properly pat a female down to where you feel confident that they don't have a weapon on them. Okay, so that there are some inhibitors to searches. What about searches in cases where there might be a dead body? So searching a dead body should be done only after the coroner or medical examiner has arrived. The coroner will give the permission, okay? And you can search around and beneath the body after the body's been removed. A lot of times your policy will dictate the extent of a search. Same thing, search systematically and completely. And when the body is taken to the coroner's office, they will also assist you in obtaining other evidence. But just one thing to remember, you don't need to know the person's identity right away. And on TV shows, a lot of times you'll see an individual, a body, and the officer or detective comes up and they roll the person over and they pull their wallet out. You can't do that. That's the coroner's job, and you don't need the person's identity right away. Does that kind of make sense? You need to protect the evidence, and at some point you'll be able to identify the person. So again, the coroner, only after the coroner gives you permission are you allowed to actually remove any items from the body. What about dogs? So this is kind of interesting. And you know, because canines are cool. Well, canines are a valuable force multiplier for law enforcement and can be trained to detect drugs and other chemicals, explosive weapons, and other accelerants for arson investigations. They can locate money. They can also find bodies. They have cadaver dogs. And a super keen sense of smell enables a dog to complete a 2 or 3 hour search, a building search in like 10 minutes when it would take officers a couple of hours to do the same thing. And dogs can also track and capture suspects and are ideally suited to assist in searching large areas with poor visibilities or large places like warehouses that may contain just thousands of items, or any area with numerous hiding places. And in addition, using canines for such purposes lessens the physical risk to investigating officers. So again, they are good for locating suspects, locating narcotics, explosives, cadavers, and more. And the use of dogs to sniff out narcotics has been widely publicized because narcotics can be concealed in so many different ways. Using dogs to locate them has greatly assisted law enforcement officers, and attempts to mask drug odors from dogs trained to sniff out drugs, a lot of times they don't work. They're futile because dogs can really smell more than one odor simultaneously. Again, canines are a great asset as it relates to investigative procedures. And there are a couple of cases in your textbook for you to look at as it relates to dogs. One of them that I would suspect that you really should look at would be Florida versus Harris. Because again, canines are a very good thing to help you locate evidence. And in different areas, again, we talked about whether it's at the airport or bus terminal, etc., or whether you're in an open field trying to track evidence. Same here, whether you're looking for a suspect here or maybe a cadaver or a body here, looking for narcotics that are inside of packages, canines are a great asset. Okay, a couple other things and we'll finish up. Let's talk about technology. So the rapid development of investigative technology has presented kind of a double-edged sword to policing. While using technology can make investigations a lot more efficient and effective, police must really take care not to overstep privacy, that line that will put their case in jeopardy. So for example, in a case called Kylo versus United States, the court held that thermal scanning of a private residence from outside of the residence is a search under the Fourth Amendment, and there would require a search warrant. Now, we use those thermal scanners at night, where if somebody runs through an open field, you can shine the scanner on the grass and you can see their footprints. But merely shining it at a residence or pointing it at a residence in the evening to detect heat, the courts felt that that was a search. and therefore it would require a warrant. Now, in another case, United States versus Jones, the court affirmed that attaching a GPS device to a suspect's car in an effort to obtain information is also a search under the Fourth Amendment, and as such required a warrant. Now, that doesn't mean you can't do it. You just need to get a search warrant to do it. So does that make sense? So, and typically in those types of cases, you would. And in this case, the investigators suspected that Jones was involved in drug trafficking, and they placed a GPS device on his vehicle to monitor his movements. Now, although the officers had a search warrant to install and monitor the GPS, in this case, the specifics on the warrant were not followed. The device was left on and monitored after the warrant expired, and was then used again to track the suspect outside the geographic boundaries that were sent in the warrant. So here in this case, the court determined that the evidence obtained was in fact illegal. So they did get the warrant. They followed that guideline, but they didn't follow the guidelines listed in the warrant. Does that make sense? So again, getting a warrant doesn't preclude you from doing your job, but you do have to follow the guidelines that are listed in the warrant. So again, we're talking about GPS devices, and sometimes even ankle bracelets. Okay, so just kind of finishing up, let's talk about, some other real quick exceptions as it relates to a warrant. So the courts have also identified some other exceptions that kind of don't fit into certain categories, like school searches or, searches of regulated businesses like gun shops or pawn dealers, places like that. So, in these special categories, they are going to require extra prudence and due diligence by investigators, whether it's because of an enhanced expectation of privacy, or the documentation of privileged communications, or presence of other sensitive information, or for other reasons. So again, we have to follow some of the guidelines on some of these different type things that might be out there. So just a quick reminder, keeping in mind the Fourth Amendment, the ability to skillfully document in writing the facts and circumstances that lead to logical inferences and reasonable conclusions remains a professional requirement in criminal investigations. Excellent investigative work is negated, and the guilty may walk free if the legal framework on which it was based can't be adequately explained. So the Fourth Amendment, remember, requires that officers' actions be reasonable and clearly outline in your report every detail known to you at the time, so that a subsequent reviewing authority has the full situation in mind, deciding whether your actions were in fact reasonable given the term we already learned, totality of the circumstances. So that's going to kind of conclude our lecture. So just to remember a couple thoughts. The Fourth Amendment to the Constitution forbids unreasonable search and seizure. Investigators must know what constitutes a reasonable or legal search. The scope must be narrow for search warrants, especially because general searches are unconstitutional. That's, again, where you could search for anything, anytime, anywhere. That's a general search, and that happened a long time ago, and we don't want that to happen anymore. That's why they have that that requirement where you have to be particular, that particularity requirement, right? On the investigative side, search patterns have been developed that help ensure a thorough search. And then while you're searching, of course, not just keeping in mind evidence and cross-contamination and all that other stuff, but Always be on your guard when you search. So not just follow the legal stuff that you need to follow, but make sure that you're doing things safely as well. All right, so a lot of stuff to cover. And again, I would recommend that you go back in your textbook and read some of that information as well to maybe fill in anything that I couldn't cover, but I think we got most of it. But that's going to conclude our part 2 lecture on chapter 4, search and seizure. So until next time.